I'm going to talk today about the decisions of the European Court of Human Rights in relation to the right to respect for family and children in the context of expulsion and the issue of residence permits. And my first slide gives you the text of Article 8 of the European Convention on Human Rights. But before we look at Article 8, I want to mention and to recall that Article 1, which we do not have a slide for, Article 1 tells us that the Convention applies to everyone within its jurisdiction, and that means everyone, not just citizens and not just people who are there lawfully. It applies to everyone within its jurisdiction simply because they are human beings and because they are within the jurisdiction. And of course, the key provision of the Convention that we're going to be looking at today is Article 8, which is in front of you now. And it says that everyone has the right to respect for his private and family life, his home, and his correspondence. And the two rights which are crucial to the topic we're discussing today are private and family life, and private and family life are connected. Family life is pretty easy to understand, though there are some refinements of the definition that the court has made, but private life is more complex, and private life includes not only the things that we would think of normally when we're talking about privacy, but it also includes many things that we would not think of when we're talking about privacy. And in particular, the concept of private life includes the number of years that you have spent in a country. So even if you don't have family members in that country, the duration of your residence there and the fact that you have lived there for many years may raise issues in relation to private life. So private life is a very important aspect of the topic we're talking about today. And sometimes when the relationship between an individual and people who we would normally think of as his family comes before the court decides to look at it as an aspect of private life because they don't consider that the relationship between this individual and what he claims is his family is sufficient to qualify as family life. By the way, I should say now that if anyone has any questions about anything that I'm saying, because obviously we can't put a complete encyclopedia into these slides, I'm very happy to answer any questions. So just make a note of them whilst I'm talking, and then you can ask them all at the end, and we're hoping to leave time for questions and answers at the end. So we're talking about private and family life, having looked at the fact that family relationships are very important, but also the relationship that the individual may have with the country where he is living and with other people who are not technically part of the family as that's defined by the European Convention. The next point then is to look at what, no, not the next slide, paragraph 2 of Article 8. Paragraph 2 of Article 8 says there shall be no interference by a public authority with the exercise of this right, and goes on to explain in what conditions interferences can occur. The important thing is to note that in order for an immigration measure to be considered an interference, that immigration measure must affect the continued enjoyment of the private or family life. If a person is removed from a country where they have lived for many years, this will inevitably impinge on their private life relationship with that country. But if they are being removed from somewhere where their family members live, the court will look to see whether those family members would be able reasonably to accompany the individual to the country where they are proposing to send him. Because what the court looks at, unless it's a violation, interference with the right to respect for private life, there will not be an interference with the right to respect for family life unless the family life can reasonably, and of course that's the key word, be expected to be continued in the country outside the country which is taking the immigration measure which has been brought before the court. So we have to look at whether there's private life, whether there's family life, and whether there has been an interference with it. We also have to make sure that whatever measure is taken by the state is in accordance with national law. And that's very important, because if there has been an error in the application of national law, then there will automatically be a violation of Article 8. The compliance with national law is central to the whole of the convention. It runs like a golden thread through all the convention jurisprudence, because respect for the rule of law is terribly important, and the state must always be sure that if it acts in a way that is in accordance with national law. And once we've established those points, private and family life, and interference, and in accordance with the law, we can move on to look at the other requirements, which is that the measure is necessary in a democratic society. And necessity is, of course, a very important word, because the phrase necessary in a democratic society is the concept on which the ECtHR emphasis on proportionality is built. It must be necessary in a democratic society. And then Article 8.2 lists the legitimate aims that will justify the measure that is being considered. So national security, public safety, the economic well-being of the country, prevention of disorder or crime, protection of health or morals, or protection of the rights and freedoms of others. And in most immigration contexts, it will be the economic well-being of the country, which is invoked to justify controlling illegal immigration. Increasingly, of course, the prevention of disorder or crime is invoked when the people who are being excluded or expelled have committed criminal offences, and those people are deemed to be a threat to the civil safety of the country where the individual is. So private family life, interference in accordance with the law, necessary in a democratic society for one of the aims specified in paragraph 2. The other crucial aspect of the European Convention on Human Rights is the right to an effective remedy. And that means that the judiciary must provide a remedy for an individual who alleges that Article 8 that we have just looked at has been violated. The remedy doesn't necessarily have to be successful, because if it was, the individual would not be bringing his case to Strasbourg. But it has to be a remedy that's capable of being successful, and the state has to show that trouble was taken by the judges who were looking at this particular issue under Article 8, carefully examined all the points that I was just making when I was describing the scope of Article 8 to you. It's absolutely essential that the national courts have carried out the exercise that is entrusted to them under Czech law of securing the rights and freedoms of the Convention, and not only carrying out this exercise, but also making it clear in their judgments that they have considered all the points that it is essential to consider before they reach their decision, including the points I was just making about the content of Article 8. Then we move on to Article 53. Article 53 is often forgotten. Lots of people never get past Article 18 of the Convention when they are reading it. They read all about the substantive rights, but they don't look at Article 53. And Article 53 says that nothing in this Convention shall be construed as limiting or derogating from any of the human rights and fundamental freedoms which may be ensured under the laws of any high contracting party or under any other agreement to which it is a party. So the European Convention on Human Rights cannot be interpreted in a way which is less human rights protective than national law, which is obvious because otherwise the measure would not be in accordance with the law, but also with other international instruments to which the Czech Republic is a party. Now, the obvious one in many cases is EU law, and it's pretty obvious that EU law must be applied by all Czech judges in a case that comes before them that raises an issue of EU law. But what I want us to look at today is, next slide, please, the important, very important international human rights standard, the United Nations Convention on the Right of the Child. And this is an instrument which has almost universally been ratified, and it's very important that any decision which is taken under Article 8 is taken in conformity with the standards of the Convention on the Rights of the Child. In the United Kingdom, we are still trying to persuade the government to incorporate the Convention on the Rights of the Child into our national law, as they have incorporated the European Convention. And indeed, in Scotland, they have done so, and in Wales, they have done so, but not in England. But in the Czech Republic, you have the benefit for children in the Czech Republic of the Convention on the Rights of the Child. And Article 3 is the crucial provision, because it says that in all matters concerning children, the best interests of the children shall be a primary consideration. So if you are looking at a measure which will have an effect not only on the individual whose expulsion or exclusion or denial of a residence permit is being considered, you not only have to look at that individual, but you must make sure that in the decision-making process, the best interests of any children who are affected by this decision are a primary consideration in the decision-making process. And importantly, it must be clear from your judgments that you have carried out this exercise. Article 3 is the crucial element of this, the best interests of the child. And it's not enough just to say, oh, well, we've thought about the best interests of the child. You have to demonstrate that you have considered the best interests of the child when making the decision that you are making about expulsion, exclusion, or the denial of a residence permit. The next provision of the UN Convention on the Rights of the Child is the right of a child not to be separated from its parents, and that is set out very clearly in the Convention. We don't have time to go into it in detail anymore, but it's very important that the Convention makes clear that a child has a right not to be separated from its parents. Of course, there will be exceptions where the child can be separated, but it's important to go back to the text of the UNCRC and to look and see if those exceptions apply. And then we have to look at Article 10, the right to family reunification, which makes clear that wherever possible, children should be able to be united with their parents. And we have that not only in the Convention on the Rights of the Child, but it's also reflected in the EU Family Reunification Directive that we will see. Most importantly in all of this is the right to be heard, Article 12. Article 12 of the Convention on the Rights of the Child requires that the child is heard in any proceedings that will affect their interests. Now, that doesn't mean to say you have to have all the children in court. Sometimes it will mean that, but it does mean that the affected children's position, and if they're very young, it will be through somebody else's voice, the affected children's position. For older children, their wishes and feelings are heard by the court, because if they're not heard by the court, the Committee on the Rights of the Child has said the best interests of the child cannot properly be considered without this. And still looking at Article 53, we now move on, next slide please, to the Return Directive. So when the state is thinking of excluding, expelling somebody who is on their territory, under the provisions of the EU Return Directive, attention must be paid to recital 22 of that directive and to Article 14, which requires the state to maintain family unity. So we see that the European law is not just a question of the European Convention on Human Rights, but the European Convention on Human Rights, through Article 53, imports all the other international obligations which states have towards families, and in particular towards children, under the Convention on the Rights of the Child and under EU law. Next slide, please. So we're now going to look at some of the cases of the ECtHR. The leading case is the case of Una and the Netherlands, which concerned the withdrawal of a residence permit and the imposition of a 10-year exclusion following conviction for a criminal offence, resulting in the applicant's separation from his partner and 2 children. The important thing about Una is that it has set out in a systematic way the relevant criteria to assess compatibility with Article 8 of the Convention. And here is a list of the criteria which the court said in Una have to be considered. And it's very important to look at each of those criteria, because if all of the criteria are met, then it will be clear that the expulsion or exclusion is not in contravention of Article 8. If only some of the criteria are met, then it may be that the situation is such that it would be a violation. It would be an infringement of the principle of proportionality to withdraw residence, to refuse residence, to expel, or to exclude the individual. And we can see that this is particularly important in the context of individuals who have committed serious criminal offences or less serious criminal offences. Sometimes we find jurisprudence where the offending state has expelled someone who hasn't actually committed very serious offences at all. That may be okay if that person has never been legally resident, in which case you still have to look and see if the individual has strong enough links to the country. But the important thing is looking at the seriousness of the requirement to cleanse, if you like, the country of this person who is a threat. And it's very interesting to look at all of these criteria. And it's unlikely that a judge who has conducted an exercise where they have examined 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 criteria and show in their judgment that they have done this, it's very unlikely that the Strasbourg court will then consider that this judge has not applied correctly the European Convention on Human Rights when considering an expulsion. So the next slide is about Maslow and Austria, and then we're looking at the same questions about the UNA criteria. Maslow is a later case than UNA, but it is an illustration of how the UNA criteria have been applied. The case of AA against the United Kingdom is a case we were involved in, where an individual who had come to the UK as a small child and been convicted of a criminal offence when a teenager and had never committed any other offences was being refused regularisation of his position, and the court found that it was inappropriate for them to expel him on the basis of an offence he'd committed as a child. Kaya and Germany, again, you will see no violation. You may be wondering why I'm drawing your attention to all these cases where there is no violation of the convention. And the reason for this is that if you look at these cases, and if you look at the way in which the court examined the conduct of the decision-making process by the national authorities, you will see that if the national authorities did what I'm suggesting, that they went through all the criteria and applied them, there will not be a violation of the convention. Next slide, please. And here we have a whole collection of cases, and you can read for yourself what the decision was here. A case called Unuane against the United Kingdom, and it again was a violation because they had failed to carry out the proportionality exercise. This was a very important case. Next slide, please. This is an interesting case because it's not about an immigration matter, it's about nationality. It was a disproportionate and arbitrary annulment of citizenship for omitting to provide information about siblings when the individual was applying for citizenship 10 years earlier. You can see the reasoning of the court in the second paragraph there on the slides. Next slide, please. We have Butter Norway again. We have precarious immigration status. That's quite interesting. Mr. Pormes had never been actually settled in the Netherlands. By the way, this decision is also available in Czech if anyone wants to go and read it. But because his immigration status had always been precarious, and everybody knew about that, knew how precarious his status was, there was no violation when he was expelled. Residence permits and family reunification. The refusal to grant a residence permit on the ground of family life, despite the existence of exceptional circumstances, was a violation. And that's a question not about expulsion, but about the regularization of an individual's situation. It's a Grand Chamber decision, and it's very important to look at it because it concerns not only the European Convention on Human Rights, but the interface with EU law. And then Gaspar and Rush to move to Malmö in Sweden, exercising their rights of free movement under the European Convention on Human Rights. The wife and children lived in Malmö. Mr. Bau lived in Malmö with them, and he went to work every morning on the 15-minute train ride across the bridge that took him back to Copenhagen to go to work, where he was allowed to work because he was a Danish citizen. Just 15 minutes had been the difference that prevented the family from living with him in Copenhagen. Then we have a look at Osman. Osman was a case that we actually took to the court, which was about a child who had been sent abroad by her parents against her will, and then she was unable to get back to Denmark afterwards. And the final case of the Strasbourg court that we're looking at is the case of Ejimson and Germany. They said there was no violation when Mr. Ejimson was being expelled. His child was only 12 years old at the time, but he had committed a lot of drug offences. The golden rule of immigration is don't commit drug offences. I think that has really covered all the cases. I should just say that we can also look at the cases that come up under EU law, but we don't really have time to go through them. There's a very interesting case called KA, which is a case number 82/16 at the Court of Justice of the European Union, which involved whether or not you could resist being expelled under the Returns Directive if you were already applying for a family reunification permit. But I think we're going to have another session if we're going to look at all those cases again. Thank you, all of you, for your patience in listening.